Honorable Justice Sadhna Jadhavji, the organizers of this event, the participants who are going to address us, the resource persons, all the advocates, those who come from the profession, students, ladies and gentlemen. The tone has been set by Deepika ji by saying, we are not anti-women, we are pro-justice. And that sums up the entire ethos of this kind of discussion that this conference is going to witness now. I have spent something like 42 years in the field of law. Initial 31 years as a lawyer, 8.5 years as a judge, and then lastly now as a professor teaching in various law colleges. What I have observed is that in our criminal jurisprudence and the way it gets administered, the administration of criminal justice, is perhaps the most neglected sphere in the apparatus of government. The police officers or so-called investigators do not have the kind of professional equipment or the education which that particular area or the force deserves. And that perhaps was the lament which was expressed by the Supreme Court in that famous Prakash Singh case, that we must separate or segregate the investigative wing from the normal law and order issues. So the very same police officer doubles up as the person in charge of law and order and then takes up the mantle as an investigator. Secondly, what has happened is that when we changed the Code of Criminal Procedure in 1973, the initial ideas that a magistrate may record the statements of the witnesses concerned and then commit the matter for trial, that was dispensed with. And we now rest content with what is called the statements recorded by the police under 161 or whatever is the equivalent under BNSS. These statements are never signed. Many of these statements are resiled from when the matter reaches the trial, so much so that in this country, the rate of conviction has never been more than 20% in any criminal matter. Now, leave aside these 498A issues or the allied matters, the rate of conviction is less than 5%. Now, that tells you the story. Number one, all these so-called under trials who are languishing in jail, 4 out of those 5 persons are bound to be acquitted at the end of the day, going by the statistics. So therefore, what does that mean? Are we not taking somebody in custody who ultimately is going to be completely discharged and found to be innocent, or at least, the crime has not been proved against him? A lawyer once actually described the entire process in a very, very pithy way. And he said that the law enforcement machinery is like cats which are employed to catch the mice or the rat. So we employ them, 10 years of running after that so-called mice, and finally it turns out that it was not a mouse, but it was a rabbit. Now, where does the society stand? So therefore, do we not or should we not insulate our system in such a way that perhaps innocent rabbits are not run after and given a chase for life? And at the end of that chase, they are left panting and sort of puffing and panting. So therefore, doesn't the society owe it to such persons what is legally and morally due to them? And that perhaps is the logic of this Ekam Nyaay. What Deepika ji said, we are not anti-women. And that's exactly the point. In society, there are, yes, Sita Mayyas, but there are Shurpanakhas as well. So therefore, one has to, as a society, be circumspect. And number one, galvanize your machinery in such a way that it leaves out chances of an innocent getting dragged to the court, an innocent getting prosecuted, an innocent getting sort of, tired of the entire process. As it was rightly said by the introducer, that, I won't like my daughters to live in that environment where perhaps even there is a slightest chance that the laws can be misused. Now, it is that misuse, that capable of being abused or misused, is something that we as a society, we owe it to every section of the population. Whoever has been victimized, maybe on the score of whatever you call 498A or any other process, or whether it is 376, certainly the man should be proceeded against. But now imagine the jurisprudence that we have now reached, or the level to which our jurisprudence has gone. There are a number of cases which may say that the statement given by the victim when it comes to charge under 376 or rape cases should be given the highest kind of, respect. Understandable. But then insulate that that's the statement of somebody and it is not being paraded as or projected as the statement of the victim. So therefore, how does one insulate that? Maybe at the first available opportunity, the magistrate may record a statement under 164, so therefore it becomes a statement on oath rather than just a 161 statement. Maybe our system must be such that if there be false accusation, then the charge of false or malicious prosecution should not be left for a second kind of trial to be undertaken after the conclusion of the first one. But a finding could be recorded by the presiding officer of the court that this being a false accusation, now the accuser must be sort of punished. So therefore, we must have these kind of safety valves at every juncture, at the stage of investigation, at the stage of conduct of trial, at the stage of inquiry by the magistrates. Now, one simple idea. Many a times what we find is that young girls and boys, they enter into relationship with open eyes. Something goes wrong, and after about a year or two comes the complaint saying that I was taken advantage of by this boy or this man, and then the proceedings begin. And in a court of law, what is that capsule which is given a sugar-coated kind of, covering is that on the pretext of promise to marry, I was taken advantage of. And so therefore, it becomes a charge under 376, 420, so on and so forth. Now, it could possibly be that, yes, that there is some truth in that. But at the same time, there are shades of gray as well. And it is those shades of gray that we as a system, we must ensure that an innocent is not being prosecuted or is subjected to unnecessary restraints or arrest. Now, in a matter such as this, how is the arrest of that man going to further the cause of investigation? Something may have happened 2 years back or some such thing. Yet, day in and day out, we find that the investigators put the liberty of that person at peril. Now, these are some of the issues which need a deeper kind of understanding. And conferences such as this, Ekam Nyaay, because this is exactly what the need of the society is, that the need of the hour definitely demands that we must give special attention to these areas, these spheres of life. And that's what this conference seeks to achieve. The idea is that let there be churning of ideas. It is through this Amrit Manthan that perhaps I think something may emerge out of that. And what may emerge may perhaps be for the good of the society, for the betterment of the surroundings, and for real cause of justice. The Supreme Court's emblem is what? Yato dharmas tato jayaha. What was that? It was an Ashirwad given by Gandhari to Duryodhan just before Mahabharat Yuddha. So Duryodhan goes to his mother and seeks her blessings. She doesn't give a blessing which is Vijayi Bhava or Jayostute. She says, Yato dharmas tato jayaha. If you had been right, you shall succeed. So whatever is the right shall prevail. Now that's the ethos of our country, that's the heritage that we belong to. That we have this attitude of nirakshira viveka, that is, segregate the grain from the chaff, segregate the truth from falsehood. Let there be pristine truth, and truth alone must prevail. And it is through these ideas, through these conferences, that this churning method has to be employed. The society requires it time and again. And if these ideas are actually sort of put to test, what perhaps at the end of this conference will emerge will certainly be beneficial to the entire society. And therefore, I must congratulate the organizers and Ms. Deepika ji in particular for undertaking this as a venture, as a mission. Thank you so much.